Chief Justice, members of the Judiciary, Chairman of the Bar Association, President of the Law Society, distinguished guests, ladies and gentlemen. This is a time of reflection on the past year and also to plan ahead. The state of turmoil in Hong Kong in 2019 has put us through the most difficult times. Many of the core values in Hong Kong have been under challenge, and the core value closest to our hearts, the rule of law, is no exception. There are many intimations of what constitutes the rule of law. Some may be described as perpetual truths and inspirational, whilst others imaginative or even misleading. There are many ways by which the practice of the rule of law is to be assessed, some based on subjective perception, while others on objective indicia. Two authoritative statements inform us the correct concept. The late Lord Bingham's inspiring book, The Rule of Law, summarized the core value as all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect, generally, in the future and publicly administered in the courts. The declaration of the high-level meeting of the United Nations General Assembly on the Rule of Law at the national and international levels in 2012 recognized that the advancement of the rule of law is essential for sustained and inclusive economic growth, sustainable development, the eradication of poverty and hunger, and the full realization of all human rights and fundamental freedoms. Given the broad perspective that the rule of law necessarily entails, I seek to highlight some of its substantive and procedural aspects. As held by Lord Diplock, the acceptance of the rule of law as a constitutional principle requires that a citizen, before committing himself to any course of action, should be able to know in advance what are the legal consequences that will flow from it. The law must be accessible, intelligible, stable, predictable, and fair for the sustainable development of any society. In Hong Kong, our legal infrastructure is set out in the Basic Law. Our legislation is in plain language and accessible at the HKEL website. Our case law is also readily accessible to the public on the internet. Litigation invariably involves competing rights, yet rights are not necessarily absolute and may be subject to restrictions. As the Court of Appeal stated in the Secretary for Justice versus the Wong Chi-fong and others case, if the individual's rights are overemphasized at the expense of observing the law, people will easily become self-serving with little regard for other people's rights and the overall interests of society, so that society is prone to fall into disarray. When disarray, such as unchecked acts of violence and vandalism prevails, it will be rule of mob, not rule of law. In ordering the continuation of an interim injunction to restrain doxing and harassment against police officers on internet-based platform, the High Court reminded that the promotion and maintenance of the rule of law is not sensibly and rationally pursued by repeated and escalating breaches of the law, and persons who commit such crimes are simply and properly described as criminals. Criminal activity does not cease to be criminal activity simply because the actor believes himself or herself to be acting for a particular, perhaps higher cause. In the Crown versus Caird and others, Lord Sachs also held this. Any suggestion that a section of the community strongly holding one set of values is justified in bending together to disrupt the lawful activities of a section that does not hold the same views so strongly or which holds different views cannot be tolerated and must unhesitatingly be rejected. Fair trial and due process are essential elements of the procedural aspects of the rule of law. The judiciary plays the pivotal role. as observed by Chief Justice Ma in the International Rule of Law lecture of the Bar Council of England and Wales back in 2015, a transparent system of law in which the community can observe that the independent judiciary administers justice without fear or favor, self-interest or deceit, with reasoned judgments available as evidence that the adjudication is in accordance with the law and its spirit, indicates the existence of the rule of law. Lord Neuberger's holding on the role of the judiciary in the Brexit case completes the analysis. In the broadest sense, the role of the judiciary is to uphold and further the rule of law. More particularly, judges impartially identify and apply the law in every case brought before the courts. In 2019, the Department continues to provide honest, independent and professional legal advice on a wide spectrum of matters to the government so that it is fully appraised of the legal implications and acts strictly in accordance with the law. Apart from representing the government in public law litigation and civil claims, the Department endeavours to ensure that government policies and legislative proposals comply with the basic law as well as other fundamental principles of our legal system. The Department also takes seriously its constitutional role of controlling criminal prosecutions free from any interference under Article 63 of the Basic Law, and all prosecutorial decisions are made after taking into account the available evidence, applicable laws, and the principles set out in the Prosecution Code. To facilitate more convenient access of the laws of Hong Kong, the Department continues to enhance the HKEL database with more laws as verified version published on it. On top of that, we have taken a number of new initiatives, and in the interest of time, only a few will be mentioned here. The inaugural annual Hong Kong Legal Week was held in the first week of November 2019 with participating legal experts from over 30 jurisdictions. This year, 2 examples showcase the unique benefits of one country, 2 systems policy to Hong Kong. First, the game-changing and groundbreaking arrangement between Hong Kong and the mainland concerning mutual assistance in court-ordered interim measures in aid of arbitration proceedings. It capitalizes on the national policy of China in its outline of the 13th Five-Year Plan and recognizes the difference of the 2 systems in the legal and arbitration context. This arrangement has made Hong Kong the first and only jurisdiction outside mainland China where, as a seat of arbitration, parties to arbitral proceedings administered by eligible arbitral institutions can apply to the mainland courts for interim measures. The second is the arrangement between Hong Kong and the mainland on reciprocal recognition and enforcement of judgments in civil and commercial matters, which was concluded in January 2019. The scope of the enforcement of this arrangement goes beyond the Hague Judgments Convention of 2 July 2019. Once in force, Hong Kong will be the only jurisdiction where certain intellectual property-related judgments would be enforceable in the mainland. With the support from the Central People's Government, the Department entered into a Memorandum of Understanding with the United Nations Commission of International Trade Law during the Legal Week to confirm the co-organization of the Asia-Pacific Judicial Summit on a biannual basis and to explore further collaboration. In the wake of the promulgation of the outline development plan of the Greater Bay Area, the legal departments in the Guangdong Province, Hong Kong, and Macau established a joint conference mechanism in September 2019 to work on projects of mutual interest at the government level. Other initiatives of the department include co-organizing with the Hague Conference on Private International Law, the inaugural Global Conference on the Hague Judgments Convention concluded last July, and exporting the Hong Kong brand Mediate First to other jurisdictions. The vast amount of professional work and the initiatives of the department would not have been possible without the dedication and hard work of my colleagues, for which I am most grateful. 2020 marks the 30th anniversary of the proclamation of the Basic Law under the Constitution of the People's Republic of China. The department will organize a conference to commemorate this. Other new initiatives include the organization of intergovernmental meetings and conferences to enhance our international stature. Importantly, the department will launch a 10-year project entitled Vision 2030 for Rule of Law. This initiative seeks to promote the proper understanding and recognition of the rule of law by studying its various elements through research, stakeholders' collaboration, and capacity building, thereby contributing to the sustainable development of inclusive and fair societies at both the domestic and international levels. Given this will be the last time for Chief Justice Ma to host the opening of the legal year before his Lordship's retirement in January next year, I would like to, on behalf of the department, convey our sincere appreciation for his Lordship's contribution to the rule of law and his efforts in retaining and attracting talent of the highest professional quality for our judiciary to administer justice. Last but not the least, a happy and peaceful new year to you and your families. Thank you very much.
Chief Justice, judges, magistrates, the Secretary of Justice, President of the Law Society, distinguished guests from overseas law societies and bar associations, ladies and gentlemen. You do not need me to tell you what an extraordinary year has just ended. A fair number of you would have participated in one or more of the mass demonstrations to show discontent with the Hong Kong government. Even more of you would have seen these protests on television screens or on social media. All of you will, I hope, have despaired when you saw serious violence breaking out, which saw some people attacking and injuring others, whilst others committed acts of criminal damage. Such activities cannot come within the exercise of the right of peaceful protest. There will be a reckoning later this year for some of the people. The police arrested several thousand people coming from all walks of life. The arrested persons are predominantly young, some are just school children, many more are university students, however many more were ordinary workers, and others had stopped working a long time ago and entered retirement. Some of these people now face serious charges which carry substantial terms of imprisonment. Many, though, have been charged with lesser public order offences not involving violence or extreme vandalism. They are, all of them, in the main, of good character. They are, in fact, representative of a large section of Hong Kong society. It's not for me to advise the Secretary of Justice about who should prosecute and for what offences. Article 63 of the Basic Law says the Department of Justice controls criminal prosecutions, and I quote, free from any interference. However, the prosecution code published by the Department of Justice reminds us that a decision to prosecute is not made just because the police have enough evidence to go to court and secure a conviction. Public interest plays a part in the decision-making process too, so that individuals or some classes of cases will not end up in court, even though there is a strong case against them. To some people, a decision not to prosecute when there is evidence which should secure a conviction may appear odd and at variance with the rule of law, which some people mistakenly think calls for a prosecution whenever the law appears to have been breached. That is an incorrect understanding. The prosecutor is looking beyond the four corners of a charge sheet to other matters, both personal to the person charged and to other matters, is a part of the rule of law. In 2006, the Court of Appeal here described this prosecutorial independence and the ability to look at overall merits of a case before deciding a decision-making to prosecute as constituting a linchpin of the rule of law. I believe there will surely be a winnowing of cases going forward to prosecution. There will, though, still be many hundreds of cases, if not thousands. They will have to be processed through the courts by judges and magistrates, with lawyers from the Department of Justice, the Bar and the Law Society playing a necessary part as either prosecutors or as defence representatives. It will be a formidable task. I'd hope that the new Bar Council will look to ways in which it can help in encouraging members to provide those services in future trials. That may mean reminding some members who have not practiced criminal law for a long time that they should brush up their skills and be prepared to help out in court so that fair trial rights, which apply to both the prosecution and the defence, may not be jeopardised. At this stage, I should pay tribute to the barristers who, working together with members of the Law Society, have provided legal assistance at police stations and magistrates' courts to persons arrested for public order and other offences. One day we'll see scores of arrests and people taken to police custody, and the next day there'll be more of the same. Police stations often could not accommodate the detainees, and the subsequent dispersal to other police stations and detention facilities presented members with significant challenges to track down their clients and to see them. Later on, these barristers will be in court with the arrested persons, in some cases waiting until 8 or 9 o'clock at night before their clients' cases came on. Only by brilliant organisation of some and enthusiasm and hard work of all concerned could the arrested person's constitutional right to see a lawyer and be represented be made safe. When later on these cases arrive in court for trial, there will be decisions that are bound to please or disappoint the participants, as well as persons who follow the cases. Sometimes stronger emotions are aroused. We have seen judges abused and vilified only recently. The reaction has been because a verdict or a sentencing decision has not met the expectations of people outside the judicial process who have a view on what should be the correct disposal of a case. The Chief Justice has said it before now, but it needs repeating. Judges do not try people differently because of the defendant's political or other beliefs. If they were to do that, they were not true to their oath of office, which bound them to do justice without fear or favour, self-interest or deceit. I wish that the words of the US Supreme Court Justice Samuel Alito were more widely known and, more importantly, accepted and understood, which are these. A judge can't have any preferred outcome in any particular case. The judge's only obligation, and it's a solemn obligation, is to the rule of law. Similarly, barristers are not allowed to let personal prejudices get in the way of providing representation to persons seeking to use their services. We have a rule in our Code of Conduct that's called the cab-rank rule. It requires barristers to act in any case in the area of law in which they practice in return for the usual fee. They must act irrespective of what they make of the client's character or his or her beliefs. The cab-rank rule is regrettably a rule that, like most regulations, is dull to read. But an English barrister from the 18th century, Thomas Erskine, stated the essence of the rule in a scintillating speech when he defended Thomas Paine in 1792. And I pause here because I know the Dean of the Faculty of Advocates in Edinburgh is in my audience. And of course, Erskine was a Scot, and all Scots advocates are the best at the English bar. Thomas Paine was a radical. He wrote a book which suggested that it was lawful for people to overthrow a government which failed to protect their natural legal rights, such as freedom of thought, assembly, and speech. The Attorney General charged him with sedition, that's to say, with exciting disaffection and hostility against the government of the day. Other barristers attempted to persuade Erskine not to take up the case because Paine was absolute poison to the government. Defending him would blight his chances to do government work because he would forever be associated with Paine and his politics. Erskine later told the jury about the pressure he came under from his fellow lawyers not to defend Paine. He said, "From the moment that any advocate can be permitted to say that he will or he will not stand between the Crown and the subject arraigned in the court where he daily sits to practice, from that moment the liberties of England are at an end." Erskine lost the case, not surprisingly, but his stubborn and principled defence of Thomas Paine so enhanced his reputation as a barrister who championed independence of the profession that 14 years later he became the Lord Chancellor. The principle encapsulated in that part of Erskine's speech holds good today, here and now. Barristers will continue to defend unpopular clients and causes, not because they necessarily want to do so, but because it's their professional duty. I should not like to see the bar have to comment again on other incidents like the one which occurred last September, when a crowd hounded a prosecutor in the High Court building for doing his job in opposing a bail application made by a young person arrested during the protest. In 1990, the 8th United Nations Congress on the Prevention of Crime and the Treatment of Offenders adopted a document called Basic Principles on the Role of Lawyers. Paragraph 18 states that lawyers shall not be identified with their class or their class causes as a result of discharging their functions. This principle, in this day and age, needs to be understood and accepted too. These are some of my misgivings for the years to come. I hope that they do not come to pass. If they do, I believe I can assure the Chief Justice that the Bar will, as ever, assist in helping the judiciary to discharge its solemn responsibilities under the Basic Law. It remains for me to wish you all better fortune in the year and a happy year of the right. Thank you.